Tapas sir, welcome first of all to Nepal. I'm glad that I'm able to pull you over to this podcast where we speak about legal education. I know you're here with your son. You flew in from Bangladesh for a personal vacation, but I have stolen you and your time to discuss about legal education in Bangladesh and Nepal. And, hopefully this podcast acts as an archive and we generate some ideas so that we pick up from these ideas in the future and strengthen the legal education between Nepal and Bangladesh and hopefully the region as well.
The pleasure is all mine. Thank you for inviting. And what you are doing is excellent and brilliant way to put the ideas in front of the policymakers.
Thank you so much. I do hope the policymakers listen to this podcast as well at some point, right? So, Tapas sir, I will start off directly about legal education and ethics because whenever international media covers about things happening in Nepal or Bangladesh or India, it's always portrayed, the politics, the judiciary is always portrayed in this idea of corruption and lack of transparency and things like that. Right? And that kind of comes to the root of how legal education is imparted to the next generation of leaders. So before moving on with my question, let me read out a provision of Professor Mizanur Rahman's book. The book is called Anti-Generic Learning and Rebellious Lawyering, Reflections on Legal Education in Bangladesh. And Professor Mizanur is both an idol for you and me, and we get to interact with him at the summer school as well. So in his book, he's mentioned the following, and I quote, "It is fair to say that ethics learning does not generally have an impressive place in our legal education. In Bangladesh, law schools' commitment to ethics learning can best be described as irregular. Perhaps so is the case with other countries in this region. It is obvious that some law schools take their responsibilities in this area far more seriously than others. But overall, there is no sustained or coherent emphasis on students' learning of ethics." Now, sir, my question to you as an educator is, how do we impart ethics in law students?
The first thing I would like to say that ethics for a lawyer, not only for a lawyer, for anyone, as a judge, as law officer of the court, ethics is very important because all of us are serving justice. We are the mechanisms of justice. So if we do not know about ethics, then there will be a huge problem between our personal demand, that what we want in monetary benefits, and what we are getting. And then that's how, to meet these ends, we become corrupted. So if we don't have an education on ethics, we cannot control this desire to get more money, to get more benefits and services in any way we want. So as Dr. Mizan has portrayed in his book correctly, that in Bangladesh, it is quite irregular. And in some of the universities in India, I have gone through their curricula. I have found that they also lack a regular course on ethics. Probably the same thing is in Pakistan and in Nepal. So the first thing is that why we need ethics, right? As I said, if we do not know the norms of ethics, then we will not be able to control our desire to be get corrupted. When I was studying in the UK, doing my bar degree, you will be astonished to hear that there was 100 mark on professional ethics.
100 marks, but was it just a theoretical paper?
It was a theoretical paper, but ethics over there in the UK, especially for the England and Wales bar, they have a very, I would say, structured rules regarding ethics of a lawyer and a solicitor. And they have examples, in this particular incident, what should be your decision. They have FAQs, frequently asked questions. They have an ethic line of the bar. So if any lawyer or solicitor falls into any dilemma due to ethics, they can call to that line. They don't need to reveal their identity, but they can ask the ethical question to them that what should I do now?
Is it like a hotline or something?
It's like a hotline. It's open. All the 5 days during the office hour, it's open. You can call them, you can email them, and straight away they will reply to you.
Fascinating.
So these things, and that's why 100 marks ethical study is quite crucial, because if you don't pass into this paper, you don't become a barrister, a lawyer for England and Wales Bar. And during that study, I have found that the ethics, the question of ethics, is so much pinned into the system that always the time, if you go to a barrister or a solicitor, the first thing that will click into their mind, that whatever advice or service I'm providing to my client, whether that is ethical, how ethical I am. That's the first thing they ask to themselves. And the judges as well, when they listen to a case, they also ask the question that whether you were ethical or did you break any ethical norms while filing this case or while bringing this suit in front of us. So I'd say that that's very important, which I see that in Bangladesh at one stage, when I became a lawyer in 2006, then we used to have a course in our bar council. This is called bar vocational course. It was a 6 months course. It was not a mandatory thing to pass the course like the bar in England and Wales. But in that 6 months course, you would have like at least 10 classes on ethics. So in those 10 classes, generally the senior advocates would have come and they would have shared their experience, that how in their journey as a lawyer, they used these ethical questions for the betterment of serving justice to the clients. And we have a ethical canon. If you go to the website of Bangladesh Bar Council, you will see on the left-hand side, there's a big canon of ethics for lawyers, where we depart 4 specific questions. One is that how do you serve your client? How do you act towards the court? How would be your attitude towards your colleague, fellow lawyer? And how would be your attitude to the public at large? So there are set of rules which you have to follow if you want to become a lawyer. And this is the same if you want to be a judge. So the main problem is that none of the law schools, they teach it as a curricula, as 100 marks.
So it's only in the bar exams or in the bar, but not in the actual curriculum of law schools in Bangladesh.
Yeah, that's like, for example, I am teaching clinical legal education in one of the public universities, which is Jahangirnagar University. Over there, probably I will take at best 2 classes on ethics.
That's not enough.
That's definitely not enough.
But then those 2 classes are also probably more theoretical, right?
Yes, absolutely.
I like how you gave the example in UK, how you're giving an application-based question and you have to see which choice would you take, the easier route or the ethical route, right, to put it across, right? But even in the Bar Council in Bangladesh, right, and the exams, 100-mark exams, are there application-based questions or is it a very theoretical?
Very theoretical. And I would say that, however, like I have heard it from the persons who marks those papers. They say that while reading those drafts, they go through the hints that whether the students have violated any ethical question.
Oh.
However, you can understand that they are not learning it as a student. So how they will manage to check it in the exam paper for qualifying to be a lawyer or to be a judge?
Okay, Tapas, sir, I'm moving on to the second question, which is about how we teach in Nepal and in Bangladesh. And I have studied in India, so I have that experience as well, right? Whenever we teach subjects, we somehow rely on the jurisprudence of the West, right? When we look at contract law, it's jitty on contracts. We always say Salmond on jurisprudence, and so on, right? But why is it that we have not been able to develop the jurisprudence of South Asia as a whole? And how do we do it?
It's a very tough questions. It's one of the reason, if I have thought about it, for example, that we have, like, our personal laws plays a crucial role when we give advice to any client or anyone, because marriage, then adoption, inheritance, like in Bangladesh. In Bangladesh, there are 4 prominent religions: Hindu, Muslim, Christian, and Buddhist. So all of these personal questions are answered according to their religious scriptures, not according to the law of the land. So if Bangladesh wants to take one single jurisprudence, then they actually have to codify all 4 of these religions and put them together. That is one way of putting it. And that's why we are struggling to have a South Asian jurisprudence in Bangladesh. But if you look into the West, that they have defined, like if you say human rights, probably the term will mean the same way. The term would be defined in the same way everywhere. But if we say it in, for example, in our Hindu context even, the term of human rights, so we'll have to take the help of Ramayana, Mahabharata, Gita, Upanishad, and things like that to give a proper definition to it. The situation of personal law of Hindus is better in Nepal, but in Bangladesh, for example, a Hindu woman does not enjoy inheritance rights. They enjoy only a life estate on the property of their husband or father, and in very specific cases. They cannot divorce. Even a Hindu male is not allowed to divorce. So there is a very crucial, I would say, a crucial trauma is going on in Bangladesh when we want to ensure human rights for the Hindu community people. As I said, like, due to this difference of religion, it becomes quite tough for us to have one single jurisprudence for this region. However, I have read the books of Avinash Sharma, and like if you follow Shashi Tharoor as well, you will see that what we can do, instead of adopting one single jurisprudence, we can perhaps adopt all our religious jurisprudence at one side, and also we can deduct the philosophical basis of those religions and we can put it together. Because in one way, if we see it, none of the religion is against human rights.
Correct.
Every single religion is saying the same thing about human rights.
Absolutely.
And when I am teaching humanitarian law or international criminal law in Bangladesh, if I compare religious textures with these human rights of the West, I found very similar things. Like, I'll give you one single example. For example, the humanitarian law regarding that you cannot kill a soldier or shoot a soldier if he is sick or already injured, or if he is praying. You will probably find the same thing in Islamic textures, in Quranic law. You will find the same thing in Hindu, Mahabharata, and Ramayana, where it is clearly written that, and one basic thing, that you cannot lie during war. You cannot lie, and you will find it in Mahabharata, right? When Oshuttama Hato Iti Gajo was pronounced by Yudhishthir, automatically his wrath came down to earth, which was flying up. So that is a depiction that how this very notion was taken by the Westerners and put into those conventions. So I would say that we can adapt from these religious textures our own jurisprudence, and we can use it through research, through negotiation and networking, which is quite lacking in this region.
Yeah.
The main thing the British people did when they left this continent is divide and rule, right?
Yes.
And since then we are divided.
So what about, like, let's take India, and that talks about the Uniform Civil Code, right? Do you think that is a step in the right direction?
I would say that that is a step towards right direction, because in Bangladesh as well, there is a close connection with SAARC and Bangladesh's movement of Universal Family Court. Because Bangladesh's movement of Universal Family Code started from 1980s. So that is when we started this movement on Uniform Family Code or Universal Civil Code. So, but right now in Bangladesh, that there is a problem among the religious minorities, that their very existence is at question, I would say. This is a very continuous process. So what they want right now, that before stepping into this shoe, they will want certain mechanisms, which I will tell later on. They want certain mechanisms, for example, Religious Minority Commission to be in place before they want this civil law to be adopted. And I personally believe that this is the right way, this how it should be, because otherwise, as a lawyer, when I'm in the court, there is a trouble in understanding that a Muslim woman, she can enjoy divorce rights, inheritance rights, but a Hindu woman cannot. So when a Hindu woman asks me the same questions, if she can, why can't I? Then I have no answer, actually. I will only have to say that we follow the scriptures, the Ayabhaga law, and that's why we cannot apply it. That's the only question.
How interesting, right? Even with like a Hindu woman's right in Bangladesh, I mean, that jurisprudence in many ways could be brought in from Nepal as well, because we allow equal succession, whether it's a married or unmarried daughter as well. But perhaps we have not been able to collaborate properly and talk about each other's jurisprudence and make an impact in policy making, that the rights enjoyed by Nepali Hindu woman is not the same for a Bangladeshi Hindu woman, right?
Yeah, I mean, as I said, there is a conception. I won't say it is a misconception, but I'll say that it's a conception among the religious minority leaders, that if they allow this kind of rights to women, a lot of women will be converted, and with that their properties will be converted, So, and that will actually destroy their very existence. And this fear of existence is actually not letting us getting unified against this very concept of Universal Family Code or Universal Civil Code.
Okay, Tapas, I'll move on to another question. So last time I visited Bangladesh for the Human Rights Summer School, that was the first time I visited Bangladesh. And, I got to know that around Dhaka itself, in the periphery, there are approximately 40 law schools. That number, I was quite taken aback by, the fact that, Nepal probably has 13, 14 and Bangladesh has 40 law schools. Right? So, but you mentioned that in the Bar Council, there are limited seats, right? After writing the bar exams or something in those lines. Could you elaborate more on that and why this, quota of seats began in Bangladesh?
First, I would like to say that yes, there are 40 plus law schools in and around Dhaka or all over Bangladesh, because law is a very popular subject, and we still need lawyers because we have a huge population. So to address the huge population, the exact or ideal number of lawyers are still not available per person. So we need more lawyers, number one. Number two, however, when these tide of law schools were opening or booming up, it was found that every law school actually was taking more than 50 students. Some schools were taking 100 students and giving them certificates. And then they were sitting for bar exams. So it was becoming impossible for the Bar Council to manage this huge number of law students. So what they did is that they just, I would say, 4 to 5 years ago, they put this embargo that you can only have 50 students each law school.
Oh, really? This was just 4 or 5 years ago?
4 or 5 years ago, that one. But the thing was, probably as we were talking earlier about the principle of introducing bar exams, that started back in 1995, 96. I would say that on every stage, you have to appear for the bar exam. For example, before that, if you had a LLM degree, you were not allowed to sit for the entrance exam.
You were not allowed, as in you're not eligible?
No, you don't need
Oh.
You were not required to sit for the entrance exam. You can automatically become a lawyer. You just go and apply to the Bar Council. They will just give you, from tomorrow, you are advocate. But then during the 1995-96, they reviewed the policy because of the quality of the lawyers. They wanted to have good quality lawyers so the general people can have a good service. So that's why at first they introduced two, I would say at the entrance level, 2 exams. In the High Court Division, 2 exams. For example, you will have to sit for a written exam and then viva for that.
For the lower court.
For the lower court. For the lower court, due to this boom, as I was saying, this boom, then now we have 3 stages of exams. Like at first there is MCQ, then there is this written exam, and then there is, for example, viva voce. If I give you the example of the last exam, around 40,000 students applied for the MCQ test.
40,000.
40,000.
Yeah, if you have 40 law schools, then 1,000.
Yeah.
I don't know. That's
because the students who were previously failed, they also joined this I would say cadre, like this category of sitting for the exam again. That's why the number is huge. Another thing in Bangladesh is that our Bar Council does not organize these exams twice a year. During COVID, there were gap for 2 years. So all these together, the number was huge, like 40,000. So out of this 40,000 in the MCQ, for example, 20,000 passed. So then this 20,000 sit for the written exam.
Oh, sorry. Yeah.
Written exam.
Yes.
So in the written exam, again, for example, another 10,000 will fail. So the next 10,000 will sit for the viva.
And it's only after the results of the first and you get qualified for the second exam, and then you get qualified for the interview.
Yeah.
So there's screening in every exam.
In every exam, it is getting screened. And then after viva, you will, like maximum, like last time, it was only 4,000 students who qualified.
So literally 10%.
Literally 10%.
And then you said the same process for High Court.
The same process for High Court, I will tell you, like if you have a master's, then you'll have to practice in the lower court for 1 year. And then you qualify to sit for the exam for the High Court Division. Because our Supreme Court has 2 divisions. One is High Court Division and another one is Appellate Division. So for the Supreme Court, to qualify to be a Supreme Court High Court Division lawyer, you will then apply after finishing your 1 year practice. Or if you don't have a LLM, then you have to practice for 2 years. And then you sit for that exam. It's a written exam. For example, every year, approximately 10,000 to 12,000 students or candidates appear in that exam. And out of that, only 3,000 to 4,000 students succeed. Right? And they join in the bar. And even our Supreme Court Bar Association does a screening process, because they again hold a viva voce to find out if the particular candidate is a regular practicing lawyer, or who is or the candidate is someone who wants to use it for certain other qualification or other job. So if they find out that a certain candidate is not a regular practitioner, then they can deny him the right to practice.
So does this mean now at the Supreme Court level as well, you have to write a separate exam, you need to have numbers of experience in the High Court?
Absolutely. As I said, like if you have a LLM, it's 1 year experience in the lower court. If you don't have a LLM, then it's 2 years experience in the lower court.
So that means very few, in terms of numbers, very few are qualified to practice before the Supreme Court.
Absolutely, very few. And then if you want to become an appellate division lawyer, there is no exam for that, but you will have to apply to the Honorable Chief Justice. And then your file is actually sent to each and every judges. They will go through your profile, they will screen it, and then they will sign it or saying yes or just signing it. And that's how it proceeds to before the Chief Justice, Honorable Chief Justice, and he is the authority for giving the power to practice in the appellate division.
That's incredible, Tapas. Now, if I, after this podcast, suggest that in Nepal we need separate exams for Supreme Court and High Court and District Court, I think the bar will cancel my license and everybody will be up in arms.
I would say that probably, like, why we didn't do it till 1995? Because at that time we had very few lawyers. till that time. But after that, this boom was there.
But there must have been resistance for this structure.
There were very few resistance because the government was in support of that at that time, because they were willing to have qualified lawyers so that the litigant people, they don't complain about the service they are getting.
That's incredible but in Bangladesh, are lawyers also members of political parties?
They are, yes.
So there must have been resistance from various parties as well. Because
there were not any resistance on this issue. I wouldn't say that they were unified about it, but there was no resistance about it. Okay. Because everybody was equivocal about one thing, that is to ensure quality in the legal profession.
That's incredible. Maybe that's a lesson that Nepal needs to learn as well, because you write one bar exams, one interview, a set of bar exams and an interview. And then if you pass, then you're directly qualified to argue before the Supreme Court. So I don't know whether we should think about changing this as well.
Maybe. Yeah. So what I wanted to say that back at 1995, till that time there were few lawyers, few people who wanted to be a lawyer in the Supreme Court. But then day by day, the number increased. The number of litigating people increased hugely. So what happened due to these stages of exams? There are a lot of senior lawyers who are still practicing in the district court level, who are equally brilliant as those who are practicing in the appellate division of the Supreme Court of Bangladesh. So they are practicing in the district court, which means that the litigating people in the district court level, they were getting quality legal service from those senior advocates, number one. And number two, the apprentices, the future lawyers, they're getting to learn from those senior lawyers. So this is incredible, because I have met so many lawyers in the district level who are quite literate, quite knowledgeable about the jurisprudence that we started talking with of Bangladesh and other countries as well. So they actually have increased the quality of the whole legal profession in Bangladesh.
That's great. Okay, Tapas sir, let's speak about like teachers, law educators in Bangladesh, and just education, the state of education in Bangladesh. Are teachers actually respected, or is there some sort of an attitude like there is in Nepal sometimes, which is if you cannot do anything in life, then you become a teacher? Is that attitude there in Bangladesh too? In
Bangladesh, the attitude is quite, I would say, quite flipped. Why? Because over there it is said that if you cannot do anything, you become a lawyer. I don't know if
so being a law teacher must be the worst category.
No, not in Bangladesh. In Bangladesh, law teacher actually have a higher, they are in a higher category, even the lawyers. As I said, like, I don't know, there is a Bangla idiom saying that jar nai kono goti, she kore okaloti. I don't know if the Nepali audience will understand it.
Could you translate it?
It means that the person who doesn't have anything to do in life, he'll become a lawyer.
I am sure there's something in our idiom as well, but maybe somebody will comment in the our YouTube channel.
So that's what I'm saying, that in Bangladesh, definitely legal academia is respected and they are quite dignified. The only problem that I face in Bangladesh is that their contribution in the making of the jurisprudence. For example, in a common law country like Bangladesh or India, the jurisprudence is grown by the precedents of the courts.
Yes.
So a law academia or a law professor does not become a lawyer, or he or she is not called in front of the court as an amicus curiae.
Exactly.
So they cannot participate in the making of this legal jurisprudence.
So that's the same in Bangladesh as well, which is interesting because you just mentioned how law teachers, professors are respected. However, the judiciary never invites them for independent, opinion to assist the court as well. Is that also because, law teachers practice law in the courts, and there's a conflict with respect to that, and they're not truly independent.
Now, in Bangladesh, if you want to be a lawyer, you cannot do any other profession. And that's why if you're a law teacher, law professor, you cannot be a lawyer. For example, if one becomes a lawyer and then he gets into a university as a law professor or a law teacher, then he will have to suspend his license to be a lawyer.
Suspend.
If you become a judge, for example, a lot of law students, they become a lawyer first and then they sit for the judicial service and they become judges. So when they become judges, they will have to suspend their membership in the bar.
Meaning, when you mention suspend, is it like giving back?
Giving back the license, saying that now I am into a different profession, I will not be a lawyer anymore. What they can do after their retirement, they can withdraw the suspension. And lots of judges do that in Bangladesh.
But are they allowed to practice in the courts where they were a judge?
So the question you asked is very vital, because the judges, the district court judges, if they retire as a district court judge, they are not allowed to practice in the district court. They can practice in the Supreme Court, in the High Court
Higher
division.
Courts, yes.
And if a justice of the High Court division retires from High Court division, he can only practice in the Appellate division.
And not within the jurisdiction of that High Court.
Not within the jurisdiction. We have only one High Court division, centralized only in Dhaka.
Oh.
We don't have a High Court division in every division.
So let's say matters that are getting appeal from
Chattogram
or Chittagong.
Yeah, Chittagong.
Chittagong. Mm-hmm. They need to come to the High Court division.
In Dhaka. Only in Dhaka.
So you don't have a federal system?
No, we don't have a federal system. We have a unitary system. So everything will come to Dhaka.
And how many judges are there in the High Court?
Now there are 100 plus.
That's still very less for a population of
that's very
how
less.
Many? 300 million?
No, it's 180 million now.
180 million people.
It's very, very less, and I hope that Bangladesh government and judiciary and the Honorable Chief Justice will decide about employing more judges in the High Court division in the future. And we need more judges in the Appellate division as well.
So would you suggest that the Bangladesh judiciary not be unitary and there be a more federal system? Would that be effective?
I agree on this point. No, I won't say that federal system, but in our High Court and in our Constitution of Bangladesh, there is provision for say, like, there could be benches of High Court division in different districts or in different regions. So there is a conversation going on within the legal fraternity right now that, there are 8 divisions in Bangladesh. So there should be a High Court division, High Court bench in every division. That will probably help the litigating people not to come to Dhaka, but because going over there.
It's also a matter of accessibility, access to justice, right?
Absolutely.
And if you have such a strict unitary system, somebody from Chittagong or northern Bangladesh will have a tough time traveling down to Dhaka for an appeal.
Absolutely. Right? So that's why there is a talk going on. I mean, I would say that a conversation. So let's see what happens. We are quite hopeful that it will happen.
Yeah. Maybe in that aspect, Nepal can be in some ways an example, just like Bangladesh is an example for us in terms of the bar as well, right? So much to learn from each other as well.
Absolutely. I agree with that completely.
Yeah. So, Tapas, I also understand that the language of the judiciary in Bangladesh is sometimes in English, sometimes in Bangla. And law schools are also teach in Bangla as well as in English, right? But we still refer to jurisprudence, which is in English. Is there some mismatch happening with our, teachings?
Yeah.
And to add on to that, it seems like our region, the SAARC region, is inherently bilingual or multilingual, right? And that language plays an important role in the judiciary as well. So do you think language plays a role in jurisprudence? And, how should our students cope up with the multilingual judicial nature?
You know that Bangladesh was a British colony for nearly 200 years. And after that, it became part of Pakistan. So during the British regime, all the laws that were enacted in the British India were in English. And then during the Pakistan regime, all the laws that were enacted by the Parliament of Pakistan was also in English. So what happened that when in 1971 we became independent through a war of independence, from Pakistan, then most of these laws, which were English, were inherited into our system. So we cannot deny learning laws in English. It's impossible because the most crucial laws, for example, Civil Code, Criminal Code, Evidence Act, then Registration Act, Limitation Act, these are all in English. Very few recent laws are getting into Bangla. But again then, the government is publishing a genuine English version of those laws so that foreign investors, especially when they're coming into Bangladesh, they can understand what kind of law we have. For example, our company law, the government has published 2 versions. And both the versions are passed by the parliament, like the English and Bangla. So if a Bangladeshi citizen wants to know, he can read the Bangla version. And if there is a foreign investor, they can go for the English version. So we cannot deny that language is crucial in Bangladesh. And also I have to say that historically, that Bangladesh is the only country where people given up their life, sacrificed their life for the right to speak in their mother tongue.
Yes.
That's the Bengali people. We did it in 1952.
That's the core of your identity.
That's the core of our identity. So it's a core value in Bangladesh that we argue in our mother tongue in front of the court. But what happened is that most of these crucial laws are in English. We are a common law country. So for the value of precedence, we refer to other countries' judgments. For example, British judgments, American judgments, Indian and Pakistan judgments we are referring because those judgments are also in English. And for example, that as I said at the very start, that human rights will be interpreted in Pakistan, in India, in USA, and in the UK. So we will get all of those ideas together and the judge will compare those ideas and then he will adapt one of them or all of them probably, and then he will state that in the judgment. So that's how English is also a very important part of our legal service.
Absolutely.
So in our law schools, when I was a law student, we used to learn in both language. Like one language is like if I say, I will repeat again, that if I say that English was more preferable than Bangla, that will not be true. And also if I say that Bangla was getting more preferred than English, that is also not true. The beauty of our law schools are that they give us the opportunity to answer in both languages, both in English and in Bangla we can answer. It is up to the student to choose. That's why in our question papers, we put English question and then Bangla translation. Or some of the schools like Bangladesh Open University, they put the Bangla question first. And then the English question follows the Bangla question. So over there, the students are open to choose any of the languages. This is the same thing in the court. In our district courts, since more rural people are approaching the district court for their justice at the very front of the law. So most of the drafting, most of the submissions in those courts are made in Bangla, but that does not debar or restrict the judges from delivering the judgment in English. If they are willing, they can deliver it in Bangla or they can deliver it in English. It is up to the judge as well. But if they deliver it in English, they will have to interpret it in the open court in front of the litigant parties so that they understand that what is the outcome.
So to add on to this, so when arguments take place before the Supreme Court of Bangladesh, do lawyers sometimes also rely on Indian jurisprudence?
Absolutely.
Because your laws are very similar, right?
Absolutely. We depend on Indian jurisprudence, we depend on Pakistan jurisprudence.
But it's challenged to depend on Nepali jurisprudence.
It is a challenging because I will tell you why. Because one of the reasons is that most of your judgments, or If I say none of your judgments are in English, probably if your honorable judges can, or if your Attorney General office, if your law ministry, they have this translation wing who can probably translate them into English, the crucial judgments. For example, the one we were talking about, the eco judgment, or the recent judgment about LGBT rights, if they were translated and if the similar matters are before a court of Bangladesh, be it a district court, be it a high court or appellate division, we can refer them as precedents that look, what is happening in the similar kind of societies.
But it needs to be a translation from an authentic source.
Absolutely. It has to be an authentic source. An authentic source is either the Supreme Court of Nepal or the Attorney General Office or the Ministry of Law. These are the three authentic sources. There cannot be any other authentic source.
Yeah, because what if all universities collaborate to have like a translation, official translation course, probably?
Yeah, they can have it. But then again, it has to be recognized by the governments of both the countries.
Correct.
Because if we do it privately and if we twist any of the words according to our own interpretation, then justice will be denied.
Okay, Tapas sir, one very fascinating fact for us about you is that you're also a prosecutor at the International War Crimes Tribunal in Bangladesh, right?
Yes.
And you have also done a little bit of court practice as well, right? How can we take the teachings of these two types of practice and bring it to a criminal law classroom?
The first thing is that we need to introduce clinical legal education more into a classroom. For example, you have referred to Dr. Mizan. I can also add Professor Madhav Menon from India and Professor Yuvraj Sangrula in Nepal. I can refer to them, that they have worked on clinical legal education in this region very hard. So, for example, if I'm a prosecutor in the International Crimes Tribunal of Bangladesh, and I'm also a practicing lawyer, if I can bring those experiences into the classroom, there are substantive law and there are procedural law that our students learn. So, if those students can be taught about the clinical part of each and every law, for example, if you are a contract law student, and if you are provided at the very end of your course to write a contract on your own, and probably some of the students can be engaged in participating into some negotiation over a contract.
We did the negotiation simulation in summer school.
Absolutely. So you see, that would benefit them. If it is a company, like I was talking with some of the Korean lawyers, that how was their studentship at those times. They said that, for example, if they're a student of company law, they will be asked to open a company on their own and then wind it up on their own. So each and every student will open a company of their own with their own article of association, memorandum of association. They have to draft everything. And then at the end of the day, they will be asked to apply for a winding up. So they will automatically know how a company is born and how a company is closed. So in India, some of the universities are doing it, but we are not doing it in Bangladesh. I don't know about Nepal, but
even in Nepal, there seems to be a lacking in this aspect as well. I know. I mean, it's also leadership, I would say, because everybody knows that this is the right way, but we need players who act as well.
So regarding, for example, criminal law, how to introduce this into a criminal law class. When I was a student of Northumbria University, I used to see that they had two co-curricular activities. One is called street law and another one is called legal aid service. They introduced students into these two aspects. Under street law, they used to go to different libraries, different places to talk with peoples like family members of accused persons, family members of victims, who would have approached those students to understand whether I have committed a crime, whether my son or my relative has committed a crime, or whether I have been a victim, to understand those things. So the students, at the very first time, they got introduced to a live case. they would work with that on their own. And then they get back to their teachers who are probably a practicing advocate as well, or was a retired judge. So they will approach them, they will take certain advice from them and reach it out to the people. So the street law can work in that way. Like every university can have that. And legal aid. Like, for example, if each university has a law clinic, designated law clinic, which can bear 100 marks, that in spite of taking certain subjects, you can become a member of the law clinic for a whole year, and one teacher will evaluate your performance. And as a part of law clinic, they will approach with legal aid to live clients. They will have an office. They will run a law firm within the university, and they will also get to know different kind of problem. And that's how they will get accustomed with the criminal law. And definitely this will benefit them along with the current system of internship, without any doubt. So I would say, like, I am trying to encourage some of the universities in Bangladesh to introduce this law clinic system into their curriculum system. Like, it will be 100 mark for law clinic, 100 mark for ethics, so that the students can get certain marks while doing what they love to do.
So I'll move on to a question, Tapas sir, which has been at the back of my mind ever since I've learned about the relationship between Bangladesh and Nepal. So one thing we get to know is that a lot of Nepali students go to Bangladesh for a medical education, right? And because of that historic development, it's been decades that Nepali students have gone there, gotten a degree, come back, practiced here, been international medical practitioners, right? But that has really strengthened the relationship of the medical community in Bangladesh and medical community in Nepal. However, with the legal community, right, there is, I would say, almost zero interaction between Nepali students and Bangladeshi students, and we have not been able to foster the same level of camaraderie as the medical professionals have, right?
Yeah.
I think we must do that somehow.
Yeah, I mean, if I place that, how we met through the Human Rights Summer School that is organized in Bangladesh by my organization, ELCOP. So what I want to say that is, actually, that interaction is nothing compared to the demand that we have. It would have been great if certain law students from Nepal visited Bangladesh for doing a LLM over there, and certain students from Bangladesh visited Nepal for doing their LLM over here. Would have been fantastic. Like, I have visited Kathmandu University School of Law in Dhulikhel, and the beautiful campus could be a blessing for any law student, especially those who are doing masters and PhD. They should do their research in this scenic beauty. And only then, like, after studying and researching for a whole day for 7-8 hours, if they stand in front of that scenic beauty, enjoying the mountain air and the beauty, all the tiredness will go away. So I would definitely encourage a number of Bangladeshi students to come up here to do their research work over here. They can do postdoc, they can do certain diploma over here. For that, there has to be a collaboration between the law schools, between the government, because there must be some sort of funding available. You should award something to those students. In Bangladesh, I guess it will not be a big deal. If there is a certain number of law students from Nepal show interest for doing masters in our public universities, definitely there are opportunities for having funding for that. So as I was saying, that some of the universities in Bangladesh, public universities, definitely have some funding for research students. They can apply for those funding, browse on their websites. Apart from public universities, there are a little number of private universities who can also offer you that. But you need to write to the vice chancellor of those universities, because generally they hold the fund. So they can disseminate it. And if that can be started, that will be hugely beneficial for this region, without any doubt. Just as we are benefiting from the medical fraternities networking, will be beneficial from the legal fraternities networking as well.
So just to add on to this thought, and this will be the final question that I have as well, right? So who do you think are the institutions that should get involved for students to be able to foster this collaboration, which will help us improve the jurisprudence of the region?
First thing that comes up into my mind is University Grants Commission. Both the countries have University Grants Commission, so they should start talking with each other. The second thing that comes into my mind that, there is Law Commission in both the countries. So they can also start talking with each other, networking, so that the judges from this country can go into Bangladesh, Bangladeshi judges can come into this country, and they can collaborate. Also, the Attorney General Office of both the countries can network in the similar way. Ministry of Education, Human Rights Commission, name it. But all these institutions can start talking with them and can exchange students or exchange researchers. And there will be a huge jurisprudence research between these institutions.
But I don't know if the leaders of these institutions actually care about legal education. So,
we have to, this very program is one of the attempt you are making.
Absolutely.
So that the policymakers start trying. I hope that some of the policymakers will hear about our cry and they will get forward and start talking with each other. On a very basic level, I would say if any interested student are listening to this, they can directly apply to their university of choice. Unless you start trying, your path will not open up. That's for sure. Because then the university to university will start talking. That, for example, your student X has applied for this scholarship. What is the situation over your university? Should we take him or not, or her? So these are the conversations that must be started by the students themselves. And then probably if the policymakers finds out, I'll correct myself, if the policymakers find out that every year 1,000 Nepali students and Bangladeshi students are applying to go to each country, then definitely they come up with some rules and regulations. And one thing I think both the countries' universities should do as well, which is that to secure a good ranking in the university ranking list. Because a lot of students come to me for advice that which university we should approach. Most of the university students do not want to apply in any of the regional universities. They are looking to Western universities.
Correct.
At best, they will look for Singapore University of Law, because their National University of Singapore Law Department is excellent. They are winning moot court championships. And then probably some of them will go to Korea. Some of them will go to China. But maximum of them will be looking into some universities in the UK or in the USA or Canada or Australia. So if our law universities can improve their ranking through research, definitely the students of both the countries will be interested to apply in those universities.
Correct. Just to finally add on to this, I'm just curious. One trend that I'm seeing in Nepal with the youth, it's kind of almost like an exodus of the youth, is because everybody seems to be more enamored by the West in Nepal, and they want to go abroad, live a life there, come back, maybe not come back, right? Because generally the youth seem to be very frustrated about what's going on in this country, the opportunities that are coming, the rising inflation and everything. Is it a similar attitude in Bangladesh, the youth?
Absolutely. Especially, let me tell you about, I found a similarity between the female students in Nepal and the female students in Bangladesh. They think that they are not heard. Whatever they are demanding or whatever they are talking, the patriarchal society is outright denying them. So, and also they think that they are discriminated at every sector, be as a lawyer, be as a judge, or be as a legal law academia. They are finding out that their voices are shut up by certain institutional heads, our so-called leaders. So if we cannot change this scenario, if this exodus continues both in Bangladesh and in Nepal, I don't know what we have in future.
Very heart-pinching thoughts, Tapas sir, and it is true as well. And I'm glad you mentioned that this is more of a feeling of the girls in Bangladesh and in Nepal. And I'm very fascinated you brought this point out because last week we had a former Supreme Court judge who was interviewed in this very studio. And the one lesson she told was she wants girl students to speak up. So I really hope we've been able to create an education, foster an education environment where everybody's heard.
Absolutely. And I will just add with one thing that in Bangladesh, the participation of girls in the judicial system has increased without any doubt.
That's great.
Even in the legal fraternity, I would say there are equal numbers of female teachers compared to male teachers. But in spite of that, a lot of female academia in Bangladesh, I know personally that they have changed their career just because they think the patriarchal structure of the university administration is shutting them up, is making them feel insecure to share their thoughts, be it on social media, be it in the classroom. So, because what will a female teacher do at best? They will portray the law from a female perspective, which is totally absent, I would say, in the interpretation of law in Bangladesh. So this has increased in Bangladesh. But the way they are being criticized, for which they are forced to change their career, I would say, and leave the country, I would say that's alarming.
Yeah. But I hope things change. On a more positive note, I'd like to also share an anecdote about my teacher of tax laws and infrastructure law from Nalsar University of Law, Neha Pathakji. What was very humbling to see around a year back was she had written an article which was published in a reputed journal in India about some implications pertaining to tax and cess. And we were fascinated to discover that the Supreme Court of Pakistan had cited her article. And to see these borders being, diluted through jurisprudence, especially between India and Pakistan, was just a very humbling moment for a lot of us as well. So hopefully that also shows a little bit of change and the step in the right direction as well.
In Bangladesh, you asked the questions before as well. I'd just like to add that some of the articles written by our law teachers are cited nowadays in our judgments. They are finding their way up there. But the way they should have been cited in our judgments, that is not taking place. Like our law teachers, 40 law schools, 40 plus law schools. So if each and every university has a minimum of 30 teachers, that is like 1,200 or near about 1,500 fraternity of law faculties. And each one of them, if write even one article, like every year, that will be 1,500 articles. So out of those 1,500 articles, if one or two are cited once in a year, that is actually nothing. That is not representing their merit in our judgment. And from that perspective, there are certain female law teachers who are researching on, sexual rights of women and how women are getting discriminated in the job sector and in labor sector. They are writing about those things. And some of them are getting cited, which is a positive sign. However, as I said, I want them to be cited more and more.
Correct. We need to respect our academics.
Absolutely.
And
without any doubt.
That's the only way we'll grow.
Absolutely. But to earn that respect, as I said, that the law teachers will have to be trained well, networked well, and do more collaborative works. Like, for example, if India and Bangladesh and Nepal law teachers, they write a certain article together, that will definitely reflect a comparative view of a perspective. And that is bound to be cited in 3 countries.
Correct.
You see?
Hopefully, we will be able to foster this in the future.
Hopefully.
Okay, Tapas sir, we've almost come to the end. And the end of our segment, we have a very interesting thing which happens. So basically, generally, you're my first international guest as well.
Thank you.
So
That is
thank
an
you
honor.
for hosting us. And generally, for my Nepali guests who I invite, I have students from across law schools in Nepal who send in video questions, right? Pre-recorded video questions. And I show them to the guests and they respond. The great thing about our region is that as soon as I told a law practitioner with an academic background is coming for this podcast, right? My students, not just in Nepal, but in India, in Pakistan, and as well as our student in Bangladesh, were very excited to send some videos to you. So they have their questions. I will play it out over here to you. And if you could just respond to them.
No problem. Thank you. That will be an honor.
From the University of Sindh in Pakistan, we have a question from Ghulam Rasool.
Hello Tapas, this is me Ghulam Rasool Kasar from Pakistan, studying at Institute of Law, Sindh University, Jamshoro. My question to you is pertaining to your experience as a prosecutor at the International Crime Tribunal in Bangladesh. What has been the most heartbreaking moment for you, and how the tribunal has been working to ensure that the next generation of lawyers in the SAARC region are aware about the learnings of tribunal? Thank you so much.
Thank you, Ghulam. Thank you for your question. The first thing is that, the International Crimes Tribunal of Bangladesh is producing 5 to 6 judgments every year. And all these judgments are kept in our website. They're in English. So if you ever visit the website, you can download them. Even certain orders, for example, charge framing order is there on our website. So you can download them and you can learn them. The best thing is that this is kind of outreach program so that everybody in the whole world can download these judgments, read into the jurisprudence that is being used in those judgments, so that you can learn that what kind of jurisprudence a national tribunal of a country like Bangladesh is producing, which is of international standard. There is no doubt about it. And from those judgments, you will see that how history is considered, how victims of past atrocities are coming before the court and delivering their judgments. The most heartbreaking part, I would say, is that the way Bangladeshi people were tortured in 1971, whenever a victim of torture, especially those who were raped and sexually assaulted, comes before the tribunal and described how Pakistani soldiers and Bangladeshi perpetrators raped them, tortured them, was so heartbreaking for me. And at times I couldn't hold my tear back, because it's so heart-wrenching that how they have sacrificed their life, And then you will have certain victims. For example, in one of my cases, I had this victim who was a child of 9 months at that time. He was thrown from his father's hug to a haystack, and then his father was killed. That 9 months child came in front of the court and described that how he missed his father. It is not possible for that 9-month-old child to describe who was the perpetrator, but he appeared before the tribunal to describe the heart-wrenching experience he had without a father for growing up, how he missed his love, how he heard from his sisters that how their father used to love them and he missed out on that love. One war child came before the tribunal and described how she was neglected by the whole society. He was ostracized by the family he was married to. And when you hear their experience, that she has become near about 50, but still people will tell her that she is a bastard. That experience, and for which she is not offered any job, she is not offered any dignity, even her kids are denied marital rights. So whenever you hear these heart-wrenching experiences, as a Bangladeshi citizen, I would find myself privileged that I missed that liberation war. So I feel sad as well that I couldn't fight for those people, victims, and as well as I feel privileged that for their sacrifice, I'm enjoying an independent country. Thank you for your question once again.
From the University of Sindh, we have a question from Hena Parmar.
Hello Tapas sir, this is Hena Parmar from Pakistan studying at Institute of Law, University of Sindh, Hyderabad. First of all, I would like to wish you a very happy Eid Mubarak. Sir, my question to you is that when you have researched the jurisprudence propounded by the courts in India, Nepal, Bangladesh and other countries in the SAARC region, do you find any common thread of thoughts in the judicial system or any common thing in the judiciary of the courts? Thank you.
Hi Hena, thanks a lot for your question, and once again Eid Mubarak to you as well and to your family. The common thread I have, that especially Bangladesh, India and Pakistan all were British colonies. So we have a certain British legacies that are common. For example, our CPC, CRPC, Evidence Act, land law process, everything are quite similar because we share the same laws on those things. If we consider that adversarial system of justice process, that is also common within us. Regarding similarities with Nepal, there might be a little difference because Nepal was never a colony. So whatever law they have, that is of their own. Recently, they are moving towards common law legal system, but overall they have a mixed legal system like common law and civil law legal system. So I have that soon we will find that adversarial legal system is becoming common all over South Asia. And if we can have the judgments translated into one common language, for example, English, then it would be better for us to network and share our jurisprudential knowledge with each other. You would love to hear that in Bangladesh, we cite not only Indian jurisprudence, we also cite Pakistan jurisprudence. In a number of cases, we have done it. So I would say that from that perspective, these jurisprudence you are developing in your country is useful to the whole region. Thank you once again.
Now we have a question from one of your own students from Jahangirnagar University in Bangladesh, Jahid Oyon.
Hello Tapas sir, I am Oyon from Jahangirnagar Law School in Bangladesh. I have been your direct student. I also participated in the 21st Human Rights Summer School organized by ELCOP last year. We had a wonderful time there. My question to you today is about the summer school. Last year, apart from Bangladesh, there were participants from Nepal and India. I got to learn so much about law school culture and legal education there. Learned quite a lot about law and legal system in Nepal and India from my friends participating last year. We could feel how much we can learn from such collaboration. We were generating ideas on how we can work together to empower people through law, which is the spirit of summer school. It would have been great to have participants from Bhutan, Sri Lanka, Pakistan, Maldives and Afghanistan too. I would like to ask you about your vision being an organizer. How do you look forward to increasing participation from law students across the SAARC region?
Thank you, Oyon. It's nice to hear your voice and for asking this pertinent question, because I believe that this podcast will be heard and seen by a lot of students from Maldives, Sri Lanka, Pakistan and Bhutan. And I will urge them to apply for next year's summer school. I remember that last year, I personally sent invitations to Bhutan Law School, then Pakistani different universities, and then Maldives and Sri Lanka as well. But I don't know why we didn't get any application from those countries, because you know that we are open to everyone. We even invite other Asian countries. For example, we send the same invitation to the Singapore University, to Malaysian universities, to Iraq and Iran's universities. So we are open to the participation of Asian students or even beyond Asia. We would love to have them. And especially this year, again, I will send invitation to the universities of Pakistan, Bhutan, Sri Lanka, Maldives and Afghanistan. If anyone is willing and they apply and comply the terms and conditions for the summer school, definitely we will be more than happy to have them. So I would request everyone to browse the website of Empowerment Through Law of the Common People on a regular basis. Very soon we will be advertising about the call for participants, and we would love to have more participants from the SAARC area. Thank you, Oyon, for your questions.
Coming back to Nepal, we have a question from Nirdesh Adhikari from Kathmandu University School of Law.
Hello Tapas sir, I am Nirdesh Adhikari from Kathmandu University School of Law. So my question is, how can we create a platform where law students from Bangladesh and Nepal can learn from each other? Can your university and ours have an exchange program established?
Hi Nirdesh, thank you for the question, and I must say that you are a student from one of the beautiful campus all over the world where you are studying law. There cannot be a beautiful campus than your campus in Dhulikhel. So back in 2004, a law school, SAARC Law Students Forum was established by Professor Yuvraj Sangrula sir. So we can, I would say that reintroduce that law forum, or we can have a similar forum like that between the students of SAARC region. I would love to discuss it with your teacher over here, and let's see if something can be introduced from my forum ELCOP to have a law students forum. Let's see. Thank you for the suggestion, and your suggestion is well taken.
Now going to India, from Nalsar University of Law, we have a question from Rashika Bodh.
Hello Tapas sir, this is Rashika from Nalsar University of Law, Hyderabad in India. I wanted to ask you that just like we students get to interact with students from other countries, such as in my college we get to interact with students from Bangladesh, Nepal and other SAARC countries, do you professors, academicians and legal experts also sit together, have meetings, and is there some way we can work on to strategize and cooperate where we can make the SAARC jurisprudence more stronger and have some more impact?
Thank you, Rashika, for your excellent question. I will recall that in 2004, there was this SAARC Law Teachers Forum introduced by, again, Professor Yuvraj Sangrula and Dr. Mizanur Rahman. And I remember that law teachers from India, Bangladesh, Nepal, Sri Lanka and Pakistan was there to start a forum only for the law teachers. So I think that needs to be reinvented and reintroduced. And I would request our presenter to talk it with Yuvraj Sangrula sir so that this can be reintroduced and this forum is revived. And that would be a good forum. And also, Rashika, I would invite you to the Summer School of Bangladesh, because over there you will probably find a good number of teachers from SAARC area who are interacting at the background. So that is also can be a different forum for the law school teachers of the SAARC region. But definitely the one introduced by Professor Yuvraj Sangrula can be reinvented. Thank you for your question once again.
Okay, Tapas sir, we have come to the end of this podcast and we still have a little bit more of pattern touring left to do. Mm-hmm. But before we end, is there anything you wish to say?
Now, my thing is that I'll just say to the students that believe in yourself, first of all, and believe that what you can give to your own country, own region. Because you see that the world is in tatters right now because of the Russia-Ukraine war, because of the COVID and the tension in between China, Taiwan and other places. So law students are required more than before to interfere, and your region, your country needs you more than before. So rather than what the country can give to you, you should ask the question that what you can offer to your country. You should definitely have a degree from one of the best universities of the world, and then you should come back to your respective country and offer your skills and merit to the development of the country. Because during your student days, you have already identified what are the problems with the country's legal jurisprudence, what are the problem with the society. So if you as a young fellow, do not work with those defects of your society and the country, then who else will work on those? And that means if you leave the country, like we discussed, like an exodus, and then you are leaving the country as it was, you are losing the hope in the country, which you should not. So you should believe in your country, in your own region, and that's how the jurisprudence of South Asia will grow, and we will be more united than before. So that's it. Thank you.
Thank you so much, Tapas sir, for coming to the studio. The whole idea of this podcast was initially to start archiving ideas about legal education in Nepal. But since I had to literally drag you to the studio, I think we've had a very fruitful discussion about ideas which took place back in early 1990s and 2000s, right? Which we really need to pick up. Our generation really needs to pick up, because these ideas were beautiful. It's just the execution, right?
Absolutely.
Hopefully this podcast also acts as an archive for future educators and future leaders in the sector of education. And hopefully we are able to strengthen the jurisprudence of our region and be world leaders as well. So once again, Tapas sir, thank you so much for coming.
Thank you. Thank you very much. I'll just say the last sentence in the sense that not only an archive, I want this program to be a catalyst for bringing change in our region. Yeah. Thank you very much.
Thank you so much, Tapas sir, and hope you have a wonderful last evening in Kathmandu, and we hope to have you back again in Nepal.
Thank you.
Namaste.
Thank you. Namaste.
हिमाल खबर नेपालको विश्वसनीय डिजिटल पत्रिका।